Hello everyone. So we are here again with another set of legal updates today. So let's see what do we have in our box today. Starting with the Article 370 abrogation. I'm sure you would have read a lot about it in the newspaper. So let's just see what kind of constitutional challenge has come up recently in the court. So, Supreme Court started hearing certain cases on the basis of on the grounds of these application of Article 70. Though Supreme Court has been hearing about it since a really long time, so it has been an issue since 2019, right? It was what was Article 370? We'll have to understand that first. Article 370 was mostly about the special status that was given to Jammu and Kashmir, right? It has always been a very controversial provision in the Constitution. And finally, it was abrogated by the central government for several reasons. Uh, and hence, though it had certain pros and cons and a lot of debates on plus and minuses were continuing since a really long time, finally, Supreme Court was also dragged in. And now it has been something which has been a topic of the town. What is the composition of Article 370? What all kind of special provisions or special things that have been given to Jammu and Kashmir? So basically, it says that Jammu and Kashmir will have its own constitution, will have its own flag, will have its own autonomy over most of the matters, but there are certain exceptions. It cannot have an autonomy over foreign affairs, cannot have autonomy over defense and dispatches, right? Basically, trade. It was disannulled, basically abrogated in 2019. And since then, Jammu and Kashmir is not given any special status like before, right? It is basically treated like any other state and union territory of the country. Now, why was it done? It was basically done to fully take or make Jammu and Kashmir the part of India, right? It would give a lot of benefits to Jammu and Kashmir's development, be it economical or social and political, right? So, since they would have integrated it in Indian Union, in Indian territory, completely without any special status being given, it would ultimately result in more economic activities, more political participation in that state, more social openness in the state, and that would ultimately lead Jammu and Kashmir to development. So currently, this has been, it has been a debate even now. And so basically, what is the issue here? Right? Main problem exists is that in constitution it was mentioned that Jammu and Kashmir, its special status under 370 can be revoked only through Jammu and Kashmir Constituent Assembly. But the thing is, in 1957 itself, Jammu and Kashmir Constituent Assembly ceased, right? It was discarded. It no more exists. Now the thing is, the challengers who are challenging this abrogation are making a point. They're contending that if Jammu and Kashmir Constituent Assembly is not existing, there's no way how Article 370 can be revoked constitutionally now, since Constitution mentioned that only this body could revoke the special status. Now, since this body does not exist, there's no way that Article 370 can be revoked or it can be abrogated from the state. So that is the issue, right? Let's just understand it in very short, though there are a lot of complications and a lot of intricacies in this matter, but we will not get into that because they are not very important from the exams perspective, right? We have to stick to the legal perspective, and this was what the legal perspective about. There are a lot of socioeconomic and political and other kind of discussions also that you would see in the newspaper, which is not very important from our exams perspective. Okay, next is about the death of some death sentences which were given to our former Navy personals, military personals in Qatar. So that is also something which was quite a controversial topic in Qatar. On the ground of espionage, they were sentenced to death, right? There were certain Indian Navy personals there, and they were sentenced to death. Now, the thing is, there were grounds of them being involved into sharing of some sensitive data, some sensitive secrets of the country of Qatar, right? So that was the basis of such harsh punishment which was given. Now the thing is, of course, it is going to uh, uh, impact a lot of things between India and Qatar. But we are again not going to get into that political discussion, right? We will be focusing mostly on the legal aspect of it, because these kind of news always allure us with the kind of debates that we see in the newspaper. We want to know more about it. Of course, we should know more about it, but if we want to stick to only exams perspective, we'll have to stick to only the legal perspective of it. Now, here, what kind of options do India have? Though India have two kind of options here. One is diplomatic and the other one is legal option. Diplomatic is simple. Basically, they'll go send the diplomats to create some pressure in Qatar, or to negotiate with Qatar officials, and there is certain agreement, 2015 agreement we call it, according to which Qatar and India, both of them have gotten into this agreement that they will transfer each other's convicted prisoners to each other, right? So if they have got certain, means if Qatar has got certain convicted prisoners, they are supposed to transfer it to India, right? So that is also a part of agreement, 2015 agreement. Or what India can do is they can involve NGOs and international organizations, several international organizations like UN as well. But what can India do legally? First and foremost thing is ICJ, International Court of Justice. If you remember, Kulbhushan case, also in that case also ICJ was involved, right? So in this matter also, India can take a recourse of approaching to ICJ. That is one. Two is India can send its representatives to Qatar for those personnels, to ensure that their rights are saved, their rights are protected, well protected, they are given fair opportunity of hearing, right? Next is a case, Madhyaman Broadcasting Limited versus Union of India. Also, very simple case. Yeah, it was mostly about principle of natural justice and freedom of speech and expression, right to freedom of speech and expression, right? So basically, this was a media channel. It was a media sector, and since last few years, Indian laws and Indian officials, authorities, they have been getting a bit stricter when it comes to the scrutiny and censorship of the media. So one of them was this Media One. Yeah, that was a channel, and there was this doubt that they might have some connection with Jamaat-e-Islami Hind, right? And on the basis of that, the channel was basically challenged, right? To which the channel later on made a contention that their right to freedom of speech and expression is getting hampered, and that is why this complete debate on right to freedom of speech and expression versus principle of natural justice and these other national security issues, that was raised. It has always been a situation in India. Media and national security has been an issue since a really long time, and this was one of them which we saw this year, and that is why it becomes the important topic from our exams perspective. Initially, Media One was given a clean chit by the Kerala High Court, but later on, later on it went to Supreme Court, and they also clean chit with respect to the prohibition of the Media One was given by Kerala High Court, and later on Supreme Court allowed it. Supreme Court basically said, yeah, you may go and start your channel, not an issue. And the only thing was that the only ground which was taken up by the Media One channel was that the restriction, freedom of speech and expression, right to freedom of speech and expression can be restricted, right? There's no fundamental right which is absolute in nature. But the thing is, it can be restricted only on the grounds that are provided in Article 19, Clause 2, right? Only on those grounds. And if those grounds are justified, only in those situations reasonable restrictions can be put on freedom to right to freedom of speech and expression. Now, why was this matter taken for appeal, right? Why Supreme Court took it for appeal? Because there are two things. First is principle of natural justice, wherein you know that it is audio altrum partem, right? Both the parties should be given fair opportunity to be heard. So it was just to ensure that Media One is also given fair opportunity of being heard to bring up their side also on the table. That was the purpose of the court to take up that appeal. That was one. Two was basically proportionality. Everywhere, wherever these kind of debate would be there, right? Like freedom of speech and expression on the one hand, and national security on the other hand, or natural justice on the other hand, or anything of that sort, there would be the measurement of proportion that would be seen. What proportion of freedom of speech and expression is at stake, and what proportion of national security or any other such ground is at stake, and then both of them would be compared. So it was basically done to check or to determine the proportionality of the case, right? And it was actually affirmed in Maneka Gandhi case also previously, wherein constitutionalization of natural justice was done. And again, this case also, uh, uh, at the end, Supreme Court in this case held that it did not basically satisfy all the grounds of proportionality standards as per law, and hence Supreme Court allowed it. Okay. Moving on, Competition Amendment Bill 2022 with respect to competition law, basically. What competition law does and what this bill is basically, aiming for. Simple competition, right? Competition Act, competition law. What does that mean? That it will basically be taking care of the competition in the market. It will ensure that the competition remains fair. Anti-competitive activities, all those practices should be aborted from the market, right? That is the purpose. What are the major points that we see in this bill, right? That the government or basically the parliament, lawmakers are coming up with? What are the new points in this bill that makes it special? The first and very foremost thing is that the deal value threshold shall be revised in a periodic manner. That is one. Two is that it is allowed. There's a body, okay, Competition Commission of India, a very important body for you to know, right? There can be certain passages, and if such name comes, you should be aware of the existence of this body. Maybe you do not know about the composition and everything. Please, you need not get into that detail. Yeah, but just know that this body exists. That's it. Competition Commission of India, that takes care of the competition in the market to ensure that nobody or no body, right, should be deprived from the benefits of the market only because someone or some other body is practicing some anti-competitive activities, right? Now, the CCI, Competition Commission of India, has been given rights to penalize companies on the basis of the global turnover now. Previously, the scene was that these companies were penalized on the basis of their domestic turnover, but now it has been extended to global turnover. So this is one of the major changes which has happened. However, there are certain criticism also about it, because it has been said that European Union also did that, and ultimately it what European Union did was they put a penalty of on the cap of 10%, right, on the overall annual turnover. It was somehow, it led to some unfair outcomes in the country. So it is being anticipated that the same thing would happen in India also. However, we are not going into those kind of analysis. We are just going to make ourselves familiar with certain things. That's it. Yeah. So that it just gets comfortable in our system. Next is definition of turnover was very controversial previously, and Supreme Court also upheld the principle of relevant turnover in certain cases, and that is also being dealt in the new bill now. Next is with respect to the mergers and acquisition, it has been reduced to 150 days, and more scrutiny is being introduced for big giant companies, so that to ensure that big giant companies should not use their giantness to curb or to dominate over small businessmen or small companies, right? So that is also something wherein the bill is focusing on. Next is Cinematograph Amendment Bill. Again, another amendment bill related to censorship. Right. Today we read one censorship kind of law also. This is the other one. Now, what is it basically talking about? The to curb the transmission of the pirated film content that we see here and there, on in the internet and in different kind of channels. These film contents, they are being circulated, and it causes a lot of loss to the film companies, right? So it is just to ensure that their rights are being protected. This bill is focusing on that. What is happening here? Currently, we have a system of classification of U, A, and UA, right? So these are the three classifications that we see in the films. Now, what is being done with the new bill is that harsher punishment is being introduced for the film piracy. That is one. And the two is that new age category has been introduced. That is UA 7 plus, UA 13 plus, and UA 16 plus. These would be the categories. So far, you would have seen, right, in the movies and yeah, you would have seen in the certificates UA and UA. Now it is going to be replaced by, basically not going to be, but it has been proposed to be replaced by UA 7 plus, UA 13 plus, and UA 16 plus. That is one. Next is with respect to the uniformity of the categorization of the film, because sometimes a film is categorized on, there are no such strict grounds on the basis of which the categorization takes place. So to make this entire certification process uniform, there are certain provisions which are being introduced. Next is why this bill, basically to combat the piracy issues, the age-based classification issues, and certain provisions actually got redundant. And to overcome that, to correct that, this bill is being introduced, right? And not only that, there are certain best global practices all around the world that is also being proposed to be introduced in the new bill. So at the end of the day, it is going to be going to have some good hand over protecting the rights of the film companies, right? Not only that, it authorizes police to conduct seize and search and seizure just in case if there's a film which is being exhibited in contravention to any law or any provision of this act. Yeah, so police can go for search and seizure as well at anybody's place. So it is going to be a stricter thing with stricter punishment now. Yes, so yes, that would be it from my side, guys. Thank you so much. If you have any questions, please put it in the comment section below, and I'll be more than happy to help you out with that. And I'm very positively hoping that all of you are high in your Josh, and we hardly have few weeks left for the exam, and you are at a very great stage of your preparation. So that would be it. All the very best. I'll see you next week. Thank you, everyone.